Welcome back, everybody. Derrick Soo, your East Oakland advocate. Well, this week we've talked about the different types of mental illness, some of the treatments, and while we're on treatments, I'm going to cover the California CARES Court Act, and um, this is something that's new. And Governor Gavin Newsom came out with this a couple years ago. I've been talking about something like this since 2017. And so uh, this is just a version of what I've been talking about. I've been talking about conservatorship courts. I know how they work. I've been through the conservatorship court with my father when shortly after he had a stroke, and this put him into assisted living. My sister, forced that upon him. And the thing that I saw about this was that while he had freedom of movement at the assisted living, he could not leave the facility. He could walk around the block, but he could not go out, do shopping, or walk across the street to the shopping center across from him. And so that is a version of forced incarceration. And so that's one of the things that we want to make sure does not happen with the CARES Court Act. And one of the things that was early on, Governor Gavin Newsom, he proclaimed when he started this that this is a non punitive uh, service for our mentally ill, and the mentally ill doesn't just cover the homeless. We're talking about families that have an individual that is very disruptive to the family, has some mental issues. In fact, I know many families that have a very disruptive person, and rather than the child being a joy in the parent's life, they are a nightmare. And individuals can act up in many different ways, especially if they don't take their medication for their disorder, and they don't keep their doctor's appointments for their psychiatric talks. So there's a lot of things that we're going to cover in this. And so making sure that it is non-punitive. This is not forced incarceration, which is one of the biggest reasons why uh, HAWG, HAWG, Homeless Advocacy Working Group of Oakland, has been against the CARES Court Act until we get more clarification as to the maximum time that a person could possibly spend in this type of forced incarceration, because that's what it is. Even though they say it's not, here's some things that are interesting. Uh, in the first 12 months, the person is required to attend all court hearings. The court will, number one, when they first arrive, will that person who is that petition to be under conservatorship, or not conservatorship, but CARES Court Act. Conservatorship is off the table right at this moment. This is only uh, treating and putting together a plan. So, number one, they get legal counsel, uh, kind of like a public defender. So, we know how good that is. That's not very good at all. And then they have to have a supporter or an advocate. And it could be a family member, it could be a close friend, or it could be a court appointed advocate. So there are a lot of options. If the person does not have a person who is willing to be a supporter advocate for them, one will be appointed by the CARES Court Act. And the purpose of that supporter and advocate and legal counsel is to walk that person through the process, and to develop a care plan to put before the judge. And so these recommend the care plan recommends treatment, medications, and also housing. Uh, and meds can be court ordered. Yes, they can be court ordered. However, they cannot be forcibly administered. So that's a good part. Whereas, kind of like John George, our Alameda County mental facility, uh, there is forced medication there. And so some of these uh, mentally ill are so stricken by their illness is that they have to be uh, put away, kind of way, kind of put in a place where, number one, they're not causing harm and havoc in the community, and number two, that they're safe, that and they have supervision. So that's one of the things here in California. The CARES Court Act is supposedly to be only for 2 years, 24 months. And then you should be exiting either into regular housing and a support system outside of the CARES Court Act, because then once you've completed it, your all of your CARES Court Act obligations. The second year, uh, it could be optional. The first year, hopefully things go well and the person is stable in housing, has an advocate, supporter, and is getting continuum of care. So that's important. But if the person is a troublesome person, meaning that they don't show up for their court hearings, they don't adhere to the Care Court Act plan. They don't talk to their legal counsel. They don't have a advocate. They could be retained for another year in CARES Court Act. And what that would be, here's some of the things that would happen in that additional 12 months. If they have not completed the court mandated services and failure to complete all of the requirements, they can be continued and moved into a conservatorship court. So that's where it comes into play. In the second year and at the end of the second year, there's a possibility of a person going into legal conservatorship. We've recently heard just Beach Boys, Brian Wilson just went into federal or into conservatorship here in California because he's having difficulties managing at his elevated age. He's in his 80s and having difficulties managing his money. And so his family has decided to put him into conservatorship. And the thing about Brian Wilson, because of his age, it's not likely that he'll come out of conservatorship. He'll die under conservatorship, just like my father did. However, we want to make sure that there is a clause for escape. In the event that they complete everything, they're on track and everything, there should be a way that they can exit the system without having any penalties or anything. So anyway, in conservatorship court, the court determines a lot of things that are going to happen. And here in Alameda County, we fought that, and there are only 7 counties out of the 58 here in California that are right now using the California CARES Act. San Francisco County is one of those. The 7 counties that are currently using the California CARES Act, California CARES Court Act. Let's see, San Francisco, San Diego, County, Orange County, Riverside County, Stanislaus County, Tuolumne County, and Glenn County. Those are the only ones right now participating in the California CARES Court Act. And they have been up and running since October 1st of 2023. So, and here in San Francisco, the San Francisco CARES Court Act already has 22 enrollees. However, that's a really low number considering that they were expecting nearly 7,000 because there's so many individuals on the streets of San Francisco. But here's the thing. In order for them to be moved, there has to be housing attached because that's one of the criteria for the California CARES Court Act. They have to go into housing. They cannot be on the street. And so Governor Newsom has said that there will be 55,000 housing units to be built. Well, out of the last 8 years, we haven't built 55,000 units across the country for homeless. So how are we going to build 55,000 for the state of California? And that's only with 7 counties participating right now. So that means if you divided that 55,000 up amongst the 7 current counties participating, that's only 7,857 housing units that will be available in each county. So that it falls far short and very insufficient for the purpose. Again, this is just a political play by Governor Newsom. This is a half-ass program that's not well thought out and is not financially stable nor properly budgeted for the future. So there's a lot of problems with the California CARES Act. That's why we have I myself, I do not support the California CARES Act in its current form. A lot of changes have to be made, and the reason why Alameda County has held off implementing the California CARES Court Act is, number one, we have a federal healthcare system that is homeless, the healthcare system for the homeless, which also helps provide housing, mental health services, housing services, and continuum of care services. We also have a full-time, round-the-clock mental crisis facility called John George, which is in the San Leandro Hills. And so many cities aren't set up with this. And also, Oakland has a conservatorship court. And so the only thing that we want to make sure, like I said in the beginning, we don't want this to be a punitive system, meaning that it's a punishment system for being homeless and not having money. And then it has to be a non-forced incarceration. So they have to be able to freely move about and mostly unlimited. There could be some limitations on where they can go, what they can do, and certain things because they could have some issues. And families who don't have homeless but have a problem child, you are eligible for the California CARES Court Act. And what you have to do, you have to go to the website, California CARES Court Act. There is a link there for you to get the forms so that you can fill out the forms and submit them to bring a person into the California CARES Act who may be having some severe mental issues. And unfortunately, again, this is not in Alameda County. It's not in Contra Costa County yet. It is only in San Francisco County. So we're looking at what's happening there. And San Francisco has a real major problem with the homeless and a lot of mental instability over there in San Francisco. So we'll see what happens. Uh, and again, like I said, here in Oakland, we have over 8,000 homeless people. Not all have mental issues. Many have no mental issues. They're just simply underfunded. They don't have the means to afford the current price of housing here in Oakland. And so that has to be put together. And there are solutions that are on the table that the city of Oakland has yet to even look at. One of my solutions is a 20-acre property out by the Oakland Coliseum. It is Caltrans property that was awarded through a lawsuit that we won. We beat Caltrans, California Caltrans, and they were ordered by the court to turn over community land trust property, which can be developed into low-cost housing. And so we have a property, 20 acres. The development cost is about $6 to $10 million to put in all the needs. And then after that, then it's just putting in the homes. So the $7.2 million that the city of Oakland got for housing 150 people from the Wood Street area, that could have put up a lot of those homes, could have filled all of that, and then also have provided supervision. And these are solutions that the city refuses to look at. And they don't want to provide housing. They only talk about temporary shelter, temporary housing, and then it's somebody else's responsibility for permanent housing. No, it's the city's responsibility for the housing. And so that's why we say we need a lot of housing. And there are nationally 161,000 unhoused people. And so we need to come up with real housing solutions, not temporary housing solutions, but long-term permanent housing solutions. We know the harm is out there, it's done, it's traumatic for a lot of people. I've been through the trauma of homelessness, and in fact, that's how I got onto Social Security disability, through the trauma that was inflicted on me and the trauma that was proven to the Social Security psychiatrist. And I was even on medications for a year. And I was approved because I stayed on medication, but I had to stay on medications for at least the 1 year. And then when I was discontinued from the doctor because I had already been approved and everything was legit, my psychiatrist was relieved of duty, but he also came down with cancer. So I have no idea where my psychologist, the psychiatric doctor that I originally saw, what happened to him. But it was a pretty serious cancer, and he was even looking at the high likelihood of not surviving the next couple of years, and that was years ago. So California CARES Act, a lot of you have been asking why it hasn't been implemented, and that's the reason why, because we want to make sure that it is non-punitive and that it is not forced incarceration. Thanks for joining me today. We'll be right back.